Okay, hi everyone. Very pleased to be able to see all of us again. It's been some years since I left the ICC myself, having been back in practice for some years as well. I never thought I would be sort of organizing another ICC event, but certainly this is not done by just me alone, and we actually have our subcommittee from the ICC Arbitration Group here in Singapore. Really happy to be able to have this event. I'm sorry, I'm working from home, as you probably can see, and I'm in my Friday's best. Many of you who have seen me live will know that I can do a lot better than this. And I have my dogs in the background, so please forgive us. But this is certainly a very good time for us to get together, and I'm really happy and thankful to ICC Singapore, i.e. the Singapore Business Federation, as well as all my fellow speakers and panelists today. You can see them on the screen, I believe. They're all there. And also a big thank you to Hazel and Abhi from the ICC who are here with us today. And I think that this particular session is going to give us a lot of insights into the new rules, basically the 2021 ICC Rules of Arbitration. So some housekeeping matters before we begin. I know that some of you may have a lot of questions and or issues to raise. Some of you were very shy, you didn't include them in the registration form, but I do know that there are some of you who want to pose these questions. Kindly do so in the Q&A box. Q&A box, I repeat. If you can put them in the Q&A box, I will be monitoring them. And if by the end of the segments at Q&A, if we don't have any good questions, you can trust that Smitha and I will probably say something controversial or ask some questions ourselves. Just kidding. We look forward to your questions. So this is really a session which will give you a very comprehensive idea of some of the key provisions in the new rules. And I think without further ado, I'd like to firstly invite Smitha to give us an opening address. I think Smitha needs no introduction. Smitha, please.
Thanks, Kit. That's very kind of you. And thank you to everyone who's joined us, all participants, considering it's a Friday afternoon. I'm glad you agree with us that discussing the new ICC rules is the best way to kickstart an exciting weekend. Before we go into the session proper, I just wanted to update that a new 3-year term has, on 1st July, commenced for the ICC Court of Arbitration. We now have a new court president. Her name is Ms. Claudia Salomon, and she's the first female president of the court. On the back of gender diversity and inclusivity, as well as cultural diversity, the newly elected court members really reflect this. There are more younger members than we've ever had before. And this one's a statistic that I really like. 101 of the 195 court members are female. Another good statistic to bear in mind is that the majority of the court are not, in fact, Europeans. This is a common misconception that most people have, and I'm really happy to see that the composition of the court for this term has actually got 21 people from North Africa and the Middle East, 23 from Latin America and the Caribbean, 14 from Africa, and most exciting of all, 34 from Asia. The strong recognition of Asia and Singapore's importance in the arbitration world is also reinforced with the fact that we now have a Singaporean serving as a vice president, one of the vice presidents of the ICC court, Mr. V.K. Raja. Mr. Raja, along with 2 other vice presidents from China and India, make up 3 Asian vice presidents on the ICC court. And that is a fantastic achievement and really underscores the fact that Asia is one of the global centers for arbitration. Now, turning to the purpose of today's event, one of the hallmarks of the ICC is stability and consistency, which is why its rules aren't frequently amended. So any changes to the rules would warrant very close attention. And the changes this time around are really geared towards transparency and efficiency. A part of efficiency is ensuring that the rules continue to remain relevant as disputes become more sophisticated and complicated. Okay, with that enticing introduction, I'm sure you're all waiting to hear about the rules and the changes. I'll pass the floor to Paul, who along with Kit, chair the Thought Leadership Committee of the ICC Singapore Arbitration Group. Over to you, Paul.
Thank you, Smitha, for the introduction, and welcome everyone this afternoon. We're going to kick off first with the changes in the ICC rules to deal with the current environment we operate in, and namely to deal with the impact of the COVID-19 pandemic. And as Smitha alluded to earlier, we're going to also discuss the drive towards more efficiency in international arbitrations. So to take us on that journey, can I first introduce Benson Lim. Benson is triple qualified in Singapore, England, and Wales, and New York, and fluent in English and Mandarin. He focuses on arbitration counsel work involving Southeast Asian and Greater China regions. He's a CIARP fellow and is listed as a rising star by the Legal 500 Asia Pacific. And I think at one point in time, Benson was my trainee, so I'm glad he hasn't picked up any bad habits from me. It turned out to be a success. And with Benson, we're very fortunate. I think Kit mentioned this. We've got Hazel with us. Again, Hazel needs no introduction, and she's one of the lead counsel of the ICC based in Singapore. And I say she has the most famous initials in Singapore, HTG, because you'll find them with every case reference number of the cases managed in Singapore. So now you know who this HTG person is. So we're really lucky that she's here with us, because she's going to give us some insight into the impact of new rules, stuff you won't otherwise get to hear about. So to kick us off, Benson, take it away.
Many thanks, Paul, Smitha, and Kit for the introduction. So let me share the slides.
Yeah, as we get that going, I will also add that Hazel will actually feature in all the segments today. We have 4 segments. So she will be on hand to share with you, case examples, of course, with all the information, sensitive information redacted. She will talk to you about the things that, she has experienced before, as well as answer some of the questions in relation to the various segments. So, sorry, back to you, Benson. I thought it would be a good filler in case we have any technology issues, which we clearly don't have today. Perfect.
That's right. So thanks, Kit. So the 4 points that we're going to discuss the next 20 minutes or so is really to take on from what Smitha alluded to, which is that the ICC rules adapts to today's reality. Now, Hazel and I are going to cover 4 points, which is on Article 345, that's on submissions by electronic means. Article 26, remote hearing. We're going to talk about the expedited procedure and the increased threshold, since it's formal introduction to our ICC rules in 2017. And also we're going to talk about the COVID note as the last point. So let's talk about electronic means. The latest amendments to the ICC rules 2021 was in Article 4, which is that the requests for arbitrations, answer to the requests, as well as the request for joinder emergency arbitrator applications, have been amended to remove the presumption that pleadings and written communication shall be sent in hard copy. Now, so if you can see on the screen, we've extracted the Article 4.4, which put the onus on the claimant to request for transmission. Now, it's sort of like recognizing that in reality, that parties today in arbitration, ICC arbitration, uses electronic communication. And maybe on this point, maybe Hazel, do these amendments to the submission or request actually make any practical difference, depending on what you see actually from day to day?
Well, I don't think it changes the practice already being done, but it certainly helps to formalize position, because in fact, most of the general communications we've been receiving from parties are already electronically. And as you know, the Secretariat communicates primarily through emails. So there's no change to the position. But if I might just add, particularly in this current situation, a lot of the other jurisdictions' postal communication services were actually affected. So for example, if you have to file a request, and if you still want to file a hard copy of the request, you may actually be delayed because your national postal services provider is not working at the moment. So these rules really help parties make clear that they have the option to give us an electronic copy first, so we can proceed on that basis if they're happy with it.
So in very much, sorry, Paul, you wanted to say?
Oh, no, since we have you on the line, Hazel, I was going to ask you, whether this improves the situation in scenarios where you have a non-participating respondent. I mean, it's becoming quite common, I would gather. And do you have any thoughts and views on that?
A non-participating respondent is always a tricky issue because it is really a question of due process at the end of the day. We leave it up to the claimant party to decide whether they wish to proceed with the notification in electronic or to serve a hard copy to the last known postal address. When the arbitral tribunal is constituted, we usually will remind the arbitral tribunal that if there is a non-participating party, they have to ensure that that party is receiving all the correspondence in the arbitration. And this can be done either by the arbitral tribunal themselves undertaking to send by courier or post the communications, or to direct that the claimant party does that. And I think most of the time they will direct that the claimant party undertakes to convey all communications to the non-participating party.
Thank you, Hazel. That's very helpful. Benson.
Yeah, I think just want to pick on the point from Hazel. I think that's absolutely right, because as part of the New York Convention, you do want to make sure that even if it's a non-participating respondent, the respondent gets the proper notice of the arbitration. And I think also it might be helpful to look at, say, the soft law guidance that we see in, say, the Chartered Institute of Arbitrators guidelines as well. So that's something to be consider on top of this adapting to the efficiency. So the next point that we thought we wanted to talk about is remote hearing. So maybe a year and a half ago, we're not very familiar with it, but I think right now, a lot of us have run through as arbitrators or as counsel, or even as witnesses, if you're so unfortunate, in arbitration hearings where it's conducted by remote. So Article 26 of the 2021 ICC rules captures this requirement for remote hearing. Now, I think that's probably a similar question I have for Hazel, which is, does Article 26, I mean, we'll go through the semantics and the details of it, but does it actually make any practical difference? I mean, you've probably seen 1.5 years of remote hearings done in ICC.
Well, it doesn't make a practical difference to parties, because actually even under the 2017 rules, as we have clarified in our ICC pandemic notes, we have already clarified that parties can have virtual hearings even under the 2017 rules. So the 2021 rules merely seek to confirm that expressly under the rules. But it does make a difference to the Secretariat, because then we can stop answering parties' questions as to whether this can be done under the rules or not.
Well, Hazel, without trying to dissect the precise wording of Article 26.1, one phrase that catches my eye is the last 4 words, the appropriate means of communication, where it's contrasted with video conference, telephone, or other appropriate means of communication. I'm not sure what other appropriate means of communication there are apart from video conference, telephone. I guess there's WhatsApp and WeChat and such. But is there any significance to this language? Is it future-proofing for some extraterrestrial form of communication, or is there something that I'm not aware of that we can communicate by?
Well, indeed, you're right. Not on the extraterrestrial point, but we do want to keep it flexible. And the point is that the communications and technology is ever evolving, and is evolving even in a faster way that we may be able to adapt. So the rules are intentionally made broad so that we can capture any new means of hearing that parties may actually come up with in future, which remains to be told.
I mean, I guess the related point is, I think we all recognize that internet connection and broadband connection is not the same across the world. And I mean, has ICC considered how it deals with situations where some parties are in more remote jurisdictions, whether it's their witnesses or their counsel, where the link is not as smooth as one would imagine, and where while you could have a virtual hearing, it's definitely not going to be the same compared to an in-person hearing. I mean, how is that being dealt with, and has that situation actually arisen?
Indeed, it has. In fact, in a lot of the objections from parties to a virtual hearing, the physical infrastructure limitations is one of the main reasons for resisting. And that may very well be true in certain jurisdictions. The witnesses at home simply doesn't have the broadband to support a hearing, especially when it's a prolonged one. What we can help is, if the deficiencies is in terms of the software or platform, ICC actually has a virtual hearing center where we provide the services to help organize the virtual hearing. but where the limitations are physical in terms of broadband or even hearing equipment like a proper speaker, that's something that we have not been able to overcome with the parties because we can't provide the physical infrastructure in every jurisdiction. So that remains the problem that parties may not be able to overcome and therefore have to stick to a physical hearing.
Thank you. Benson, back to you.
I guess there's also to take on from what Hazel said. There are I think ICC has offered practical guidance in the note to parties, right, about when a virtual hearing may be appropriate and what are the steps that are required to do so. And in terms of whether a virtual hearing is appropriate, I think that is something to be asked that maybe from our experience and from parties' experience, it might not be that a remote hearing is suitable for all cases. But it was a good test to run through this remote hearing and obviously a clarification, the 2017 rules, in particular Article 25.2, right, Hazel?
That's correct.
Okay, so on remote hearing, we move on to the next one, and that is, and it's also on the same theme, which is adapting to the reality of today, and that's expedited procedure. Now, I think for many of the audience members, you're probably very familiar with this, but let me just touch on briefly on the history of this expedited procedure rules. It was formally introduced in 2017, the previous edition of the rules. But when I say formally introduced, the reason why I say it is because the 2012 rules, Article 38 of that rule, did mention about parties agreeing to shorten the various time limits. Now that's still in the 2021 rules, Article 39, but the reason why expedited procedure rules were formally introduced was because generally parties in dispute find it hard to agree on terms of anecdotal a shortening of the timelines. I'm not so sure, Hazel, I mean, we do see that this threshold obviously being increased. It's the idea of capturing more cases. I'm not sure, does the ICC, I mean, do you guys see more expedited procedures rules? I mean, what's the numbers that you're seeing since its formal introduction in 2017?
We certainly do, and I think it's reflective of parties' concerns over the speed and cost of arbitration. There's certainly been a consistent upward trend in the number of EPP cases since we introduced it in 2017 formally. We've seen the numbers more than double from 2017 to 2018 and almost double again from 2018 to 2019. Last year in 2020, we had almost 100 new EPP cases. So certainly this is something that we see parties accepting and preferring to use when it's appropriate.
Well, he said, well, we have you. I was just wondering, there is a provision in the rules that provides for parties to agree to use expedited procedure in circumstances where the quantum is not within the threshold. Is that commonly activated by the parties? I mean, clearly EP is becoming quite popular, but in a situation where you're exceed the threshold, what's been happening? Has that been quite a common occurrence?
Indeed, there has been quite a bit of uptick in the opt-in to the EPP procedure, even when the amount in dispute is above the 2 million threshold under 2017 rules. In last year alone, we had 6% of our EPP cases actually opted in by parties by agreement, even though the amount in dispute is more than 2 million. And this was one of the main reasons why we decided to increase the threshold as well, to take into account parties' actual preference, and also to accept the fact that disputes are becoming more and more complex and the amount of dispute in average has been increasing as well.
And just to take on to the last point about how parties themselves have obviously been quite proactive in taking key elements of the ICC rules to increase efficiency, we bring us to the last point of today's talk, I mean, my segment at least, on the mitigating COVID-19. Now, there is an ICC Guidance Note, as I think most of us will know, that was issued in 9th of April 2020. Essentially, the idea was that in ICC arbitrations, there were already some aspects which do not require the physical presence. Now, one example would be the pre-hearing, the first procedural case management conference. And And also in this note, I think there was, Hazel, correct me if I'm wrong, I think there were a lot of references to the guidance that were ICC regularly issues, like the notes on the parties and tribunals on the conduct of the arbitration. And I just wanted to, so post-pandemic, Hazel, do you see that some of the measures that have been in this guidance note will continue to be applicable to parties and with the view of making arbitrations more efficient?
Indeed, I think so, and I certainly hope so. A lot of work was done into getting the pandemic pandemic note out, and the note actually offers very practical advice and checklists on what parties should consider, for example, when going for a virtual hearing, and what kind of virtual hearing protocols they may wish to agree to. So it is meant to be a tool to be used and not just as in theory a guidance. I do hope that parties continue to make use of it, and it will definitely stay relevant, especially since I think virtual hearings will no longer be the exception and will certainly be a key consideration even in future arbitrations post-pandemic.
Well, thank you very much, Hazel and Benson. I think that's been very helpful in dealing with these two provisions. Clearly, the landscape has changed, and I'm sure these new rules will help us all. Kit, over to you.
Yeah, thank you. Thank you, Paul. Thank you, Benson. And of course, thank you, Hazel. I know that Hazel doesn't need an introduction, but, you know, we like to also mention that, you know, I actually had her bio, which I was supposed to read, but since everybody knows Hazel, I don't think we need to read through her entire bio. Just suffice to say that, you know, she was also an arbitrator herself. She was a center director for the SIMC and also an accredited mediator. So, you know, she does bring to the table a lot of experience on her own, and also having spent some time in China, she is also very experienced in that particular in this particular region. We move next to the next segment, which is in relation to complex arbitrations. And I firstly want to thank, you know, Benson, having kept to the time right down to the dot almost, and having taken into consideration Smitha's opening address as well. We are very good for time. I'd like to encourage you to still send in the questions that you have, that you may have. We do have a couple of questions already, so that is a good start. But we will now move on to the next segment, and Hazel will continue to be with us in this segment. And for those who have just joined us, this next segment is all about complex arbitrations, and with us to discuss and to lead the discussion on complex arbitrations is Christine Artero. Christine is a full-time arbitrator with the Arbitration Chambers Singapore and Fountain Court Chambers in London and Singapore. She's educated in both the civil law and the common law traditions, and she's admitted to the Paris Bar and as a solicitor in England and Wales. Christine's experience spans a broad range of commercial disputes, and she has served as a sole arbitrator, co-arbitrator, and as well as presiding arbitrator in arbitrations administered by, you know, name it, the ICC, the SIAC, LCIA, HKIAC, so on and so forth, as well as in ad hoc arbitrations. Prior to launching a career as an independent arbitrator, Christine worked in private practice at Sherman Sterling, and she also was counsel at LCIA, overseeing the administration of many arbitrations, and she was also tribunal secretary to over 80 arbitral tribunals at the arbitration chambers. Side point, Christine and I first met in Paris over dinner and a lot of wine. So very happy to have you with us today, Christine. So please, without further ado, take it away, Christine. Thank you.
Thank you, Kate. Thank you very much. I'm just worried I'm not going to be as good as Benson in terms of time because, yeah, joinders and consolidation. We had a quick chat with Hazel the other day, and what I thought was quite a dry subject actually led to lots of discussions, and it was actually really interesting. So I hope we managed to get that through you. Let me share my screen. So is it fine? Yeah. Okay. So today, complex arbitration, we wanted to touch upon three things. So the first one will be joinders and the new Article 7.5. The second point will be on consolidation and the amended Article 10B. And the last point will be on the new Article 12.9 on the court's power to appoint the entire tribunal in exceptional circumstances. So starting with joinder, which I think will take us the most time. So that's just this slide I thought would give you just an idea of what the work that has been done. It's just quoting 7.1 and 5, which are the most relevant to our discussions now. So basically, what we could do before the new rules, before the 2021 rules, is that no additional party could be joined after the confirmation or the appointment of the tribunal, unless all parties, including the additional party, would agree to the joinder. So that has been relaxed for enabling more joinder by the 2021 rules by adding the provision 7.5, which states that any request for joinder made after the confirmation or appointment of any arbitrator shall be decided by the arbitral tribunal once constituted and shall be subject to the additional party having accepted the constitution of the tribunal and agreeing on the terms of reference where applicable. So 7.5 basically allows a request for joinder to be served after the appointment of the tribunal. It gives the arbitral tribunal the power to decide on the request, when previously it was a power that only the ICC court had. And now it's no longer necessary that all parties agree to the joinder post-appointment of the tribunal. One party can disagree to the joinder and the tribunal will have to rule on it, but the additional party has to agree to the joinder. Before I go into the conditions of the joinder of 7.5, something that came to my mind when I was reading more closely the provision is that it refers to the request can be made after the confirmation or appointment of any arbitrator. So initially when I read it, I thought we can file a request for joinder once the appointment is in place. But rereading it, I realized that actually, yes, but also maybe before, when we have a 3-member tribunal and when the ICC has confirmed the 2 co-arbitrators nominated by the parties, but the presiding arbitrator is yet to be selected and full tribunal appointed. Am I getting it wrong, Hazel, or is that right? And maybe you can take us through the process.
You're absolutely right. And maybe to provide some context, I'll just explain how the process actually works for joinder before the 2021 rules. Before the 2021 rules, the parties can submit a request for joinder straight to the Secretariat. And this can only be done before the constitution of the tribunal or the confirmation of any arbitrators. What this means is that if there's a sole arbitrator, clearly before the sole arbitrator has been appointed or confirmed. If it's a tribunal of 3, before any of the co-arbitrators are confirmed, and normally the ICC court will confirm both co-arbitrators at the same time, and then the president at the next decision. So before the confirmation of any co-arbitrators, you can still file a request for joinder, but once any of the co-arbitrators have been confirmed, you can't under the 2017 rules. And you may have seen reminders from the Secretariat right from the beginning when we notify the request to you that any request for joinder has to be submitted before constitution. And that's what it means. But under the 2021 rule, the door has now been opened for parties to submit a request for joinder even after the confirmation or appointment of the arbitrator. And this is essentially the essence of the new Article 7.5. What parties have done since the implementation of the 2021 rules is, because sometimes the tribunal is already in place, they sometimes do send the request direct to the arbitrator with us in copy, because we are always in copy.
Absolutely. So I was actually thinking, that was another question I had for you. I was thinking, okay, if you've got the tribunal in place, parties will naturally go to the tribunal and file an application, right? Again, that was my thinking initially when I read the provision. Then I realized that in 7.5, the ICC refers to the request for joinder in capitalized letters, capitalized words, so defined. So I looked at 7.1 where it's defined, and then I realized maybe if it's a defined term, actually it should be served according to 7.1. So 7.1 would mean with the ICC. So I was wondering if that's the case and if parties comply with that. But maybe before you reply, that question comes with another one, with everything, what should be in your request for joinder, what should you put in there? So again, if you take it, the request for joinder as a defined term under 7.1, I take it that it should comply with 7.1, so be filed with the ICC. Second, that it should also comply with 7.2 and 7.3, so 7.2 will be about all the requirements about what the request should contain. So a quote of the existing arbitration reference, name of all the parties, including the additional party. There is also reference to articles 4.3 C, D, E, and F. So description of the nature of the dispute, the arbitration agreement, etc., the reliefs sought. So practically speaking, I was wondering, does it go to the tribunal? Does it go to the ICC? Does it have to fulfill all these conditions as it does under 7.1 when it's served before the appointment of the tribunal, basically?
So the contents of the request for joinder has not been changed. So the contents of a request for joinder, whether under the 2021 rules or the 2017 rules, will still have to comply with the Article 7.1 to 3. So it still has to contain all the elements in the articles. That has not changed. If you go strictly by the rules, the request for joinder should be submitted to the Secretariat, regardless of whether it's before Constitution or after Constitution. Right. But what we have observed in practice is once the arbitral tribunal has been constituted, parties tend to always include them in the correspondence. They don't take them out. So we just have to keep an eye out for it. And when we see something that resembles a request for joinder, like for example, if a party makes a claim against an additional party, before there is a formal request for joinder, we will have to catch that. The Secretariat will have to catch that, and we will have to step in and ask the parties to file a formal request for joinder. That's something that we did before and even after the amended rules. And if we see that a proper, complete request for joinder has been submitted, we will still go through the first step, which is to formally notify the request for joinder to the arbitrator or the arbitral tribunal and the additional parties and invite comments. But then it will be up to the arbitral tribunal to take over after that to decide the timelines for what they want, what submissions they want, in order to decide whether to allow the joinder or not.
Right. Okay. And in this provision, so we can see that one of the conditions for 7.5 to work is for the additional party to agree to be joined. The additional party obviously must be a party to the arbitration agreement. And the additional party must agree to the constitution of the tribunal and to the TOR if any TOR has been signed at that stage already. So I was wondering if actually the applying party gets all of that done and agreed before applying and before filing the request. So it's already all set out in the request. I guess so, because it has to be, it's kind of a precondition, right? So do they do that?
In the ideal world, it would be great if they did. And in some cases, they actually do. So in some cases, they actually say in the actual request that, by the way, the additional party has no objections to being joined. That makes everything a lot easier, even though we still have to write to the additional party to confirm that they indeed have no objections. But in the real world, what actually happens is sometimes we have to specifically ask for that because it is not clear from the request whether the additional party actually agrees to all these or not.
And then in terms of the submissions, so you said that basically the ICC will pass on the ball to the tribunal then to decide on the timing of the submissions. So I was thinking, as you can tell, I never had the case of a joinder under the new rules just yet. But so I was thinking that the submissions I would invite would be first, if it's not clear enough, depending on the circumstances, first for the additional party to confirm all of that they agree to the joinder, they agree to the constitution of the tribunal and to the TOR if there is any TOR. Second, I would invite a submission from the other side. And then if the other side disagree to the joinder, then I would probably invite reply from the applying side, and then proceed to decide on the joinder. Is that what you usually see?
That is what we anticipate will be seen, but there is actually we've not actually had a case yet within our teams for actual application of Article 75, but this would be what is expected. And I think that most of the time the arbitral tribunal may want to hold an actual case management conference with parties to just decide the timelines, whether they want it to be concurrent or one after another. So you're absolutely right. That is the process that we foresee should be implemented by tribunals under the new Article 75.
Okay. And then I was wondering if it is the additional party that wants to be joined, how would that work? Because this provision does not apply to this particular case, or I guess the additional party just reach out to the side that will apply on their behalf, or how would that work?
Practically, for the additional party to be aware of the arbitration in the first place, they must be in touch with one of the parties.
Right.
So usually it is that party who will bring in the additional party, and then the additional party will address us directly. So usually it's linked to one of the existing parties to the arbitration.
Okay, thank you. Moving on to the consideration. So once we've got this request for joinder and we've heard all the submissions, we've received all the submissions from the parties. So what does the tribunal has to consider before deciding? So the second part of, I actually split 75, so it's easier to read. So that's the consideration of the tribunal. This 7.5 sets out a few conditions. It's a non-exhaustive list, and it includes prima facie jurisdiction over the additional party, the timing of the request, any possible conflict of interest, and the impact of the joinder on the procedure. So when I read that, I had three comments that came to mind. The first one, I'll tell you all, Hazel, and maybe then you can tell me what you think. So the first one was about prima facie jurisdiction. So as for anything, the tribunal does not have to officially decide that it has jurisdiction over the additional party, but prima facie jurisdiction to proceed and join that additional party. That means that later on, after the joinder has been successful, the opposing party could file a challenge to jurisdiction that saying that the tribunal does not have proper jurisdiction over the additional party. So that's my understanding first. Then about the next three consideration, timing of the request, conflict of interest, and impact of the procedure. I read them kind of together. So the timing of the request and the possible conflict, I think should be seen in light of the impact they would have on the arbitral procedure. So I think they're both linked to the impact of on the procedure. That's the way I would read it and consider them, I think. And finally, another thing that came to my mind is about any potential conflict of interest. It clicked with Article 17.2, and I think Paul will talk to us about that later on. So I won't really go into this, but 17.2 and this consideration for joining any additional party. I think it's the same logic under the new rules, that it gives the tribunal this additional power to say, no, I don't want to join this additional party, or no, I don't want to accept this new counsel or additional counsel, because it will raise a conflict of interest and have a real negative impact on the arbitral procedure. So I think as soon as I saw this reference to conflict of interest, it just brought 17.2 to my mind, and I think it's in the same spirit. So those were my takeaway from those considerations. But Hazel, what do you have to say about those?
Oh, I would say you're absolutely on point and correct on that. The tribunal's decision on allowing the joinder of new additional parties is without prejudice to any decision it may make on jurisdiction thereafter. So even though they allow the joinder of additional parties, they may still subsequently decide they have no jurisdiction over the additional parties. The prima facie jurisdiction at this stage is a very low threshold. It's a bit similar to the court's consideration under 6.4. So it's a very low threshold, and it's on a prima facie case. So definitely there will be situations where even though additional parties can be joined, they may decide they have no jurisdiction further down the road. And as for the link with Article 17, which is the tribunal's power to exclude counsels if there's a new counsel that raises a conflict. We'll be talking about that further down the road in the last segment, but the concerns are the same. If the additional party is joined too late in the proceeding, for example, just before the hearing, then clearly this will be a relevant consideration that the tribunal may take into account when deciding whether to allow the joinder or not.
And do you have any other considerations that would come to your mind, or those are pretty broadly written? I was just thinking if clearly it would be a tactical move, or but I mean there are no real other consideration that came to my mind when I was thinking about it.
Well, we tried to capture most of the key considerations that we think the tribunal should take into account, but as you've already highlighted, it's not an exhaustive list. So certainly there'll be times where there may be other case-specific elements which the party will take into, which the tribunal will take into account. But right now, I can't think of any other considerations not already captured either.
Okay, thank you. So before we move on to consolidation, I just wanted to summarize for all of you that so an additional party under the new rules, an additional party can be joined either before the constitution of the tribunal, that would be under 7.1, and the consent of all parties, including the additional party, is not required, and the ICC court will decide. After the tribunal is constituted, or after some members of the tribunal have been confirmed, any additional party may be joined if either all parties, including the additional party, so agree, and that will still be 7.1, or the arbitral tribunal, once constituted, will decide that the additional party should be joined, provided that the additional party accepts the constitution of the tribunal and agrees to any TOR that has already been signed. So that's it for joinders. We can move on to consolidation and the amended article. Wait, sorry, I'm going back. Article 10b. So this amendment is to enable more possibility of consolidating cases, as I understand it. Before, so the situation with the 2017 rules, Article 10b referred to claims made under the same arbitration agreement in the singular. So that meant under the same contract. So, and the ICC court interpreted this article strictly, so that if you had, for instance, a case where you have party A and B, are parties to arbitration 1, under contract 1 and 2, and both contracts have the same arbitration clause. And then you have arbitration 2 with party A and C under those two same contracts with the same arbitration clause. You could not consolidate those arbitrations. So different parties, same contract, same contracts, same arbitration clauses, and you cannot join. You couldn't, consolidate under the 2017 rules. Under the 2021 rules, it's been clarified that all claims in arbitrations are made under the same arbitration agreement singular or agreements plural. So in the case the example I just gave, you could actually now consolidate those two arbitrations when they involve non-identical parties. So that's under 10b. So we're basically addressing a situation where you've got multiple contracts containing an identical arbitration clause and different parties. Under Article 10c, there is a slight amendment, as you can see on the slide, but this is more to align, as I understand it, to align the wording used in B, to align it in C, to put it in C as well. So now, if I understand correctly, Hazel, you can correct me. So you've got now 3 possible scenarios where you can have consolidation. So under Article 10A, when all parties agree to consolidation. Under 10B, when the claims are based on the same arbitration agreement, singular, or on several identical arbitration agreements, and the parties are not the same. So just to clarify this, I had an example and question for you. So you've got three parties, A, B, C. Parties to a shareholder agreement and a share purchase agreement. Both share purchase agreement and shareholder agreement contain the same arbitration clause. Okay. Party A and B are parties to arbitration A under those two agreements. And party A and C are parties to arbitration 2 under the same contracts. So both arbitration can be consolidated.
That is correct under the new Article 10B rules. The mischief that the revised article is really trying to address is the fact that in the arbitrations nowadays, parties don't just rely on one agreement. Sometimes, in a lot of cases, they actually rely on more than one arbitration agreements in multiple contracts in the same arbitration. Previously, under the 2017 rules, we won't be able to consolidate cases where even though the same two contracts or more are relied on in both arbitrations, we can't consolidate because it's in the multiple, it's not in the singular. But with this new amendment, we can actually have the leeway to do that. Because I think previously the court found it a bit constrained to not be able to consolidate something that makes clear sense to be decided at the same time. Like in the example you've given, in a shareholder dispute, where the parties may rely on both the shareholder agreement and the share purchase agreement. Even if there are multiple arbitrations relying on these two agreements, in the past, we won't be able to consolidate because they are in the because the term is in the singular. Right. So it really is that essence of the change. And I think this would make a difference in today's world because arbitrations are getting more and more complex. So we have to recognize that parties do not just rely on one arbitration agreement anymore.
So if you still have in mind my example just now, so I had a question. If arbitration 1 between party A and B was under the share purchase agreement only, and arbitration 2 between A and C is under the other agreement, and both agreements are clearly linked. One party is the same, but the parties are different in the two arbitrations. The arbitration clauses are identical. Can you consolidate, or do you have to have the dispute arising out of the same agreements in both arbitrations?
So in that scenario, if the first arbitration only relies on the share purchase agreement, while the second arbitration only relies on the shareholders agreement, right. Even if the arbitration agreements in both these contracts are identically worded, it would not be able to go under 10B or even the revised 10B, because the requirement of the same arbitration agreement or agreements is still there under 10B. And the court interprets the requirement of same strictly. And
as meaning same contracts.
That's right.
Right, because those clauses are identical, but they're not found in the same contracts, right?
Yes. So when we talk about the same, we don't just mean identically worded. Identically worded arbitration agreements are not enough. It has to be the same arbitration agreement or the same arbitration agreements.
Right.
So in that scenario, it wouldn't be able to consolidate further under the 2017 rules or 2021 rules.
Thank you. So I was just saying that we've got 3 scenarios. So under 10A, 10B, we just talked about it, and under 10C, so we could consolidate 2 arbitrations when the parties are the same. The claims are made under different arbitration agreements, but the disputes in the arbitrations arise in connection with the same legal relationship, and the ICC court will find that the arbitration agreements are compatible, right? So this, I guess, this just widen the possibilities of consolidation. Takes a more liberal approach to consolidation and gives more importance, I guess, also to the compatibility of the relevant arbitration agreements in all this change. So we'll have to look a bit more into that. and it could certainly improve time and cost when we can consolidate multiple contract, multiple parties arbitrations. Hazel, anything else you wanted to tell us about consolidation before we move on to the final topic?
Not really. I think we have pretty much covered the main points. It is a very technical process. So in case of actual consolidation, if parties have any questions regarding if arbitral tribunals have any questions about the actual implementation of this clause, they can always reach out to the Secretariat to ask any questions regarding the new rules, because it may not always be clear what needs to be done under this rules.
Right, thank you. So our last point on complex arbitration is about the new Article 12.9 in the rules. So I've read that some commentators have said that this may be the most controversial modification in the new rules. So let us first say what it is, what is the aim of the new 12.9, and discuss it a bit. So 12.9 says that notwithstanding any agreement by the parties on the method of constitution of the tribunal, in exceptional circumstances, the court may appoint each member of the arbitral tribunal, so meaning the entire tribunal, to avoid a significant risk of unequal treatment and unfairness that may affect the validity of the award. So I think the question that or how this article came about is because parties have the right to contract and to agree to go to arbitration and to draft their arbitration clause in the way they want. So can they do that do they have an unlimited power basically to agree on the terms of the arbitration agreement? And could they agree to have an unfair or unequal method for appointing their tribunal? That's the question behind this article, and particularly when you have a multi-party situation. So I think the first point we have to make about this new article is that its aim is to avoid unequal treatment and unfairness in the way the tribunal is appointed. And because this unequal treatment or unfairness could affect the validity of the award at the end of the day, because it could be said under the public policy of the seat of the arbitration that it was unfair and it was against the public policy of I guess, the seat, but probably also the place of enforcement of the award, right? So I'm looking at the time to see how much we can say about this. So this article is really meant at addressing pathological arbitration agreements and to ensure compliance with the principle of equality of the parties in the designation of the tribunal, the arbitrators. And the court should only use this power in exceptional circumstances, it says, but it doesn't define what they are. So parties could say that the court could abuse this power, right? There is no definition of what exceptional circumstances will be. But again, the threshold, I would imagine, should be really high because the court has to make this provision legitimate and justified in the eyes of the parties first, because if not, it would backfire and actually you could challenge the award on the ground of Article 5.1d of the New York Convention that the tribunal was not constituted according to the parties' agreement. And that's exactly the opposite of what it wants to achieve, because it says in the article that it is meant to avoid a negative effect on the validity of the award.
Indeed, the threshold is very high. And the fact is, since this was implemented, this was introduced, it has never been implemented. That goes to show how rare this clause will ever be used. And the idea really is to address pathological causes where the unfairness, and not just any unfairness, the unfairness must be of the nature that would affect the validity of the award. And that really is where the court is coming from. One case that I have in mind, which really triggered this amendment, was where we had an arbitration agreement for 5 arbitrators. the 4 arbitrators will be appointed by each of the shareholders in the agreement. And then the 5th one will be appointed by all 4 arbitrators. And in that case, what happened is that 3 of the parties, their interests were actually aligned. And so it's a situation of 3 against 1. And if we had gone ahead with the arbitration agreement, what would essentially happen is the 3 on one side will be able to have the majority on the arbitral tribunal. Of course, the tribunal will always be neutral and impartial, but it's also important that the appointment process must be fair. So it was, in that case, we didn't have Article 12 at the time because it was under 2017 rules. So the court had to resort to Article 42, which is in the general power to preserve the validity of the award, to appoint each member of the tribunal. But now that we have Article 12, when faced with situations like that, the court will have the additional tool to address any such unfairness which may affect the validity of the award. So the threshold is very high.
Yeah, I could tell. And I was thinking of all the scenarios when this provision could apply. And I was thinking if basically, right, if one party has much more control over the designation process, if there is a unilateral right to appoint or to have control over the list of potential candidates, that's what came to my mind for that scenario. But I guess it's also, when we discussed earlier, we thought it would be a good time to remind the parties that don't go too wide when you draft your arbitration clauses, and just keep to the normal draft.
Don't be too creative.
Don't be too creative. I think that's it from us for complex arbitration.
I think we have some questions. Do we want to take it now or do we want to take it later?
I think we probably will need to take those questions during the Q&A. And I think maybe Hazel, because we still need you for the next session, but I think you may need to take a drink, have a sip of water. So don't worry about that. We will now move on to the next segment on transparency. And Paul Sandosham will take us through that segment. We'll still have Hazel continue to be on this segment, but you may want to have a drink break. Christine, we will also be sending you some questions for you to prepare. So Paul, take it away, please.
Thanks, Kit. Okay, moving on to the next theme of transparency. And first, we're going to talk about third-party funding, hot topic. So going back in time, Singapore first introduced a framework for third-party funding in 2017 for international arbitration proceedings and related court and mediation proceedings. You would have read in the news just last week that from 28th June 2021, the Ministry of Law will extend the third-party funding framework to cover domestic arbitration proceedings, certain proceedings in the Singapore National Commercial Court, the SICC, and related mediation proceedings. So we'll look at the changes in the ICC rules that deal with third-party funding. And keeping with the theme of transparency, we'll then discuss the recent change requiring the communication of court decisions to parties. So could I just introduce the speakers who will be covering this segment? First, Jonathan Ellis, Managing Director at Secretariat in Singapore. He specializes in quantification of damages and valuations, in particular in disputes, context for litigation, arbitration, and expert determination purposes. He has provided oral testimony in both court and arbitration and has been engaged as a tribunal appointed expert. And second, David Llewlyn, a practicing lawyer, arbitrator, and academic. He's Managing Director of David Llewlyn and Company LLC. He sits as an arbitrator in international commercial disputes and is a professor practice at Singapore Management University School of Law and Professor of Intellectual Property at King's College London. So, Jonathan, you want to kick us off on third-party funding?
Yeah, thank you very much, Paul. 1 second, let's... Right, okay, thank you very much. So, as Paul mentions, we're going to start off with Article 11.7, which, as he mentioned, deals with the disclosure of funding parties, and we'll come on to the nuance of that in a little bit later. Article 11 itself deals with general provisions for the arbitration tribunal. With the addition of Article 11.7, there's now an obligation on the parties to disclose, and I'm reading this off here, the existence and identity of any non-party which has entered into an agreement for the funding of claims or defences and under which it has an economic interest in the outcome of the arbitration. Just breaking this down a little bit, I just wanted to highlight a few of these areas. So the first point I thought was quite interesting is Article 11.7 sits in Article 11, which is a general provision for the arbitral tribunal. However, the obligation itself is actually on the parties to disclose the information. This is easily explained because the parties are the people who generally have access to the information that's needing to be disclosed. So I think it's obvious why that's happening. The second point here is economic interest. I thought it would be helpful to just expand on that. Here we're talking about where one of the parties is receiving some sort of funding arrangement, where the amount repayable is contingent on the award or the outcome of the arbitration. And finally on this, the one that I did quite like is each party must promptly inform effectively all the stakeholders in the arbitration proceedings. So you need to tell the Secretariat, you need to tell the tribunal, assuming if it's constituted, and you need to tell the other parties in the proceedings. As stated in the rule, in the addition, it's to assist the arbitrators and prospective arbitrators to comply with their duties under Articles 11.2 and 11.3. So this is to, and I had to remind myself what those were, so I'll read this out. Is to identify any facts or circumstances which might be of such a nature as to call into question the arbitrator's independence in the eyes of the parties, as well as any circumstances that could give rise to reasonable doubts as to an arbitrator's impartiality. Now, I think these kind of, there's lots of reasons why this might happen, but kind of I just wanted to highlight some limited examples of where these facts and circumstances could potentially sow reasonable doubts as to the impartiality of the arbitrator. The most obvious one is where the arbitrator is an actual shareholder in a funder, or where the arbitrator are themselves invested in one of the funds of a funder. There would be a direct conflict and a direct benefit to the arbitrator of having a favourable award against the funding party if he's going to receive some monetary reward from that down the line through his investments. There's times when it's a little less clear because, for example, the arbitrator may be assisting a specific funder more generally and sit on the funder's investment committee, or maybe have advised the funder during the due diligence of the case on some part of it. There may not be any direct access to the information specific to the dispute or the decision process in that. However, there is a relationship there, and that needs to be considered as to whether it gives rise to reasonable doubts. Going on to the point that I mentioned at the beginning, it's worth noting that 11.7 specifically does not discuss third-party funding, i.e. professional funders. Rather, it keeps the definition of a funder much broader, which is helpful because it covers the whole gamut of funders across the world. There is some helpful guidance, and thank you, Hazel, for pointing this out to me. The ICC put out a note, which is entitled Note to Parties and Arbitral Tribunals on the Conduct of the Arbitration 2021. And it sets out a few examples of what Article 7 would not normally capture. And I think that's quite helpful here. So the first one is intercompany funding within a group of companies. That's not anticipated to be caught here. Fee arrangements between a party and its counsel, which obviously in Singapore that is less relevant given the restrictions there are here, but places like the UK and the US where counsel do have CFAs and sometimes quite complex agreements with their parties. And the final one, which I quite liked, which was an indirect interest in the arbitration. And the example that was given here in the note was being where a bank granted a loan to a party in the ordinary course of its ongoing activities, rather than specific funding of the arbitration process. This is an interesting distinction, sorry, quantum expert here, because I can think of circumstances where the party's ability to pay is actually contingent on them winning the arbitration, but it's not expressly within those terms of that lending agreement. So that's a very interesting point. I think just generally parties will need to carefully consider the terms of their agreements as to whether they need to disclose them or not, and disclose these relationships more generally. I think kind of from my discussions, the inclusion of the rules around funding demonstrates the recognition of funding and third-party funding in international arbitration. Obviously, I come from the UK. It's pretty normal for parties in disputes to have access to funding options. I think the Association of Litigation Funders was set up in November 2011. And in 2013, the former president of the UK Supreme Court, Lord Neuberger, observed that funding is the lifeblood of the justice system, which helps maintain our society as an inclusive one, which are quite large words, I would say, about funding and the importance of it. But it does set out the scene for how it sits in dispute resolution, specifically in the UK there. Also, from my discussions, I think Article 11.7 has been welcomed by the third-party funders, i.e. professional funders. It allows potential conflicts to be highlighted early on and strengthens the place of funding in the arbitration community and cements it in the rules. So, all a good thing. Thank you, Paul. Over to you.
Well, Jonathan, thank you for the good summary on Article 11.7. And again, I hate to scrutinize the wording of the article, but looking at it, it seems the obligation is merely to disclose the existence and the identity of any non-party involved in the funding arrangement. But does a party have to disclose the terms of the funding agreement actually signed? I mean, do you have any views on that?
Under this article, no, is the short answer. So this, as you rightly point out, it's the identity and the existence of that. So you do need to name them, but the actual terms of the funding agreement don't need to be disclosed under this. It's a different question about whether you do want to disclose them. Obviously, as part of the costs of the arbitration, I think that's 38, Article 38, it deals with that. That parties can provide the funding agreement as support of that, and I will look this up again, because they need to provide the reasonable legal and other costs incurred by the parties for the arbitration. So as part of that submissions, I've seen agreements being provided for. Hazel, is there anything else from the ICC on that point?
No, and I confirm that the terms of the agreement doesn't have to be disclosed, but it will be up to the arbitral tribunal later on to decide whether they need additional disclosure or not, because it does depend on the circumstances of the case.
I mean, some parties may find this new rule rather intrusive because, I mean, one view is that, well, it's none of your business how I get my money to fight my case. I mean, perhaps I could ask David whether he thinks this will change parties' approach to third-party funding in the context of ICC arbitrations.
Well, I think the effect will be relatively limited, certainly in Singapore, because obviously the legal profession rules already require the disclosure of third-party funders falling within the definition in the Civil Law Act of funders, which obviously is much narrower. It's professional funders in the terminology adopted by Jonathan, rather than this broader notion of any non-party. So in Singapore, we already have Rule 49A of the professional conduct rules, where we're supposed to notify the other parties, and indeed the court and the tribunal, of the existence of any third-party funding contract related to the costs of these proceedings. So, and I think the fact that this is being, as it were, brought out into the open is, I think, as this session is headlined transparency, and Smitha at the beginning came out with one of the words of the century, which is diversity, and as one of the white old men, the only white old man on this panel, I think I'll come out with another word of the century, which is transparency. And I certainly think that if you open it all, then it's much better. The parties are on an equal footing and know relevant issues. But of course, this particular provision is specifically in order to assist the prospective arbitrators and arbitrators in complying with their obligations to disclose conflicts of interest. So it's in a way more limited than the type of obligation that we've already got in Singapore.
Thanks. Thank you, David. One of the reasons given by claimants for their reluctance to disclose third-party funding is this belief that once they do so, it invites an application for security of costs, security for costs. I mean, Hazel, is that a fair assessment, and is that sort of fear really founded or unfounded?
Well, generally, no. We have not seen an increase in the application for security for costs just because there's been a TPF or third-party funding disclosure. But then again, it's early days yet because this has only been implemented since the 1st of January 2021. But I do question whether the mere presence of a funding party, does that necessarily mean that the party is in financial risk? Because from what I understand, a lot of these third-party funders, they themselves have a large team that actually examine, they're very picky about the cases they choose, and they actually examine the merits of the case before they decide whether to fund this or not. So I'll put it out there that maybe the presence of a third-party funder goes to show the strength of the case rather than financial difficulties. That's the food for thought right there.
Good point, Hazel. And I think there are also many instances where it's not merely insolvent companies. I think there are many operational companies who use it as a way of taking their fees off their balance sheet and getting someone else to pay for it. I guess one last question for you, and since we have you here and clearly getting your insight insofar as you can disclose it, has the ICC had to consider conflicts following disclosures of third-party funding arrangements, and how does the ICC deal with these conflicts?
So far since this has been implemented, we have not had any conflict issues arising from the disclosure. And one of the reasons could be because we remind parties to disclose this right from the start when we notify the request. So normally this comes up before we even constitute the arbitral tribunal. But it has been discussed when we were deciding these rules, and in the event that parties do not comply with this obligation, or they forgot they had a funder, and then in the course of the arbitration proceedings, they made a belated disclosure. I think what we will do is we'll treat it like any other additional disclosure during the arbitration. We'll have to invite comments, and if there is a challenge, we'll have to deal with the challenge as per any usual challenges of the arbitrators.
Right. Thank you, Hazel. With that, let's move on to another, we wouldn't say controversial, but interesting change, which is Appendix 2, Article 5, the communication of reasons of decisions, not the tribunal, but of the court. And you'll see that they do decide many things, and most of the time they decide and parties don't really know the reasons or the rationale behind some of the decisions. So David, you want to take us through this?
Sure. Yes, this is quite an interesting development. Whether it has a lot of consequence, it remains to be seen, because we've already had a year ago a change on the part of the ICC beyond the 2017 rules, where they didn't have to give any reasons. They said that they may give reasons about a year ago in a note, and then here, with effect from the beginning of January this year, upon request of any party, the court will communicate the reasons for the 6 specified circumstances. And it's important here to note that any request for the communications of reasons must be made in advance of the decision in respect of which reasons are sought. So you can't afterwards, once you've got the reasons, once you've got the decision, say, I'd like the reasons now, please. And so that's quite important. And the other important point, and we've already heard one reference to exceptional circumstances from Christine. In exceptional circumstances, the court may decide not to communicate the reasons for any of the above decisions. And the two important decisions, or the two important areas, I think, where it is likely that parties may request the reasons are the two of those 6 on there. And really the effect of the arbitration agreement, if we can switch to the next slide, really, the decisions for which reasons can be requested in likelihood, Article 6.4, questions of jurisdiction. Here, a decision on whether and to what extent the arbitration shall proceed with regard to the parties and also claims such as whether all the claims may be determined together. We've heard some of the discussion about that, and whether the court is prima facie satisfied that an arbitration agreement may exist. And also Article 14.1, and we've heard about that from Christine already, where there's a challenge of an arbitrator, whether for an alleged lack of impartiality or independence or otherwise. And here, again, this is one of the areas where from now on, the court can be asked to provide reasons. So it's, again, in the interest of transparency, the court will give the reasons, and it's an interesting development, mainly because nobody else has taken this step. KCAB, SIAC, HKIAC, LCIA, they don't have this right for the parties to have the decisions given if required. And so it's certainly a move towards transparency, and we'll see what happens.
Oh, thank you, David. Yeah, clearly very interesting. A lot more work for court members. So Hazel, would you agree with David in terms of his views on decisions, matters where the court would be expected to give a decision? And I mean, do you actually consider that parties will be asking as a matter of course? And since these rules have come into force, have you seen any requests from the parties?
Well, we've certainly seen many requests for reasons. Since 2014, when we first started the practice of communicating reasons, we've actually issued about 53 decisions. And indeed, as David has observed, the majority of the decisions requested are on the challenge of arbitrators. There is, of course, no cost consideration when you ask for reasons. We don't charge you for the additional reasons that we give you. It's part of the service that we provide, and also part of Alexis Moray, our last president's commitment to greater transparency over the court's decisions made in ICC arbitrations.
Having said that, ICC has still kept its sort of safety net with the exceptional circumstances wording in the provision. I mean, are you able to shed some light in terms of in what circumstances the ICC would politely tell the parties, sorry, we're not telling you much more?
Certainly. I mean, parties will always continue to be more and more creative, and therefore we always have to be on the guard for that. There are three main situations I have seen where we would not communicate reasons. One is simply where the request was made after the decision has been made, because as the rules provide, you have to ask for it before. And this has to be taken into account by the court when they deliberate the decision as well, because the actual court will have to draft the reasons. In practice, what happens is we will inform the court before they make the decision that reasons are required. Usually a court reporter will be assigned to prepare the draft reasons, report the matter to the court, and then get involved in the drafting of the reasons. So that is one of the reasons why you can't ask for it afterward, because all that was not in place. The second main situation is when the request for reasons is actually a disguise for a reconsideration. For example, in a case where the decision has already been made and the party has asked for reconsideration together with the reasons. This would not be allowed because when the decision was first made, the request was not made before that decision. So you can't, as a backdoor, try to get reasons by asking for reconsideration. The third is where the request was in relation to decisions which doesn't fall under the clause where reasons can be requested. So there is a reason why we limit it to those situations. And if your requests don't relate to one of those decisions, then reasons will not be provided. But so far, those are the only instances where I see reasons have not been granted. Most of the time we do.
Thank you. And one last question, which I think is perhaps in the minds of most people on this call. Is there a risk that the provision of reasons could lead to challenges, whether in the course of the arbitration or after or during enforcement or in any challenge proceedings? Once you put down your reasons on paper, it does open the door to parties scrutinizing it and trying to find fault with it.
Well, this is my personal view, and I really don't think it would, because I do think that if parties wanted to challenge the decision, they would do so regardless of whether the reasons were provided. And I'm sure the able lawyers advising the parties will find some way to challenge it without our reasons even. So I don't think the provision of reasons would inspire a party who was not already intending to challenge that to suddenly start a new action. So in short, I don't think it would.
Great. Well, thank you, Jonathan, David, and Hazel for your invaluable contributions on this session. And I'll hand over the time now to Kit to round off.
Thank you, Paul, Jonathan, and David, as well as Hazel, for this very interesting segment. Certainly some controversial points, which I believe, could be things that many of the attendees are also thinking about. I want to thank also the attendees who have been giving us questions. There are several of them which we have already decided we will answer later during the Q&A. We're sorry if we cannot answer all the questions because there have been quite a few that have been streaming in, but maybe we'll just quickly finish up the final segment as well. I mean, we not quickly, Paul, as in Paul Tan, don't worry, you will still have your time, which we will be giving you. So the last segment is on the tribunal's powers, which I believe will also show up some very interesting points. Paul Tan will be the will be our discussion leader on this particular segment. Paul is a partner in the Formal Law Alliance of Clifford Chance and Kavanagh Law, where he heads up their litigation practice for the region. He is also an international arbitration specialist. He focuses on disputes across Southeast Asia with deep experience advising on complex issues of public and private international law. And obviously, Paul has also advised many clients, including multinational organizations, as well as financial institutions in the region. Paul sits on the ICC Commission for the Belt and Road Initiative. And now I will ask Paul to share his slides and also to lead us in the discussions. Thank you so much.
Thanks very much, Kit. Very good afternoon, everyone. I don't think my section will take too long. I know I stand between you and your evening plans, so we'll make quick work of this. The two provisions that I'll be dealing with have to do with the tribunal's authority to deal with certain situations. The first is in relation to a party's attempt to introduce new counsel, and second, in relation to facilitating settlement of the dispute, both of which have been sort of brewing in the background, but the position, I think, has not been entirely clear as to what the tribunal's authority might be in those situations. And so it's good that the ICC rules now make it quite clear exactly what the powers are of a tribunal in those situations. So the first is Article 17, which I think has been alluded to in one of the earlier presentations already. And essentially, it does two things. First, it requires parties to inform the tribunal and the other parties as to any changes or introduction of new counsel and representation in the proceedings. That's clear. I think that's obvious that it should be done, and I think that has been a practice in any event. What is perhaps less obvious is the tribunal's power, which is now enumerated in Article 17(2), to the power of the tribunal, once it's been constituted and having listened to all the parties, actually exercising a power to exclude new party representation in certain circumstances, including, I think most importantly, where it may present an issue of conflict, whether actual or perceived. And this might be thought of to be a little bit controversial, but it does, I think, move the dial a little bit in terms of where we are in the absence of such a provision in the rules. I think some of us may know of a couple of cases, exit cases actually, where this situation has arisen and the tribunals have taken slightly differing approaches because of the absence of a clear power to exclude new party representation. And so just to run through the two cases very briefly, because it gives context, I think, to what the new ICC rules might actually mean. The first is a case involving Slovakia. And in that case, Slovakia had attempted to appoint a new barrister as co-counsel shortly before the hearings. But there were concerns raised about a potential conflict of interest because one of the tribunal members happened to be a door tenant at the very same chambers that the new barrister was at. And leaving aside the question as to whether or not barristers from the same chambers present an issue of conflict, the reasoning of the tribunal in that case seemed to have taken a fairly robust view of their powers, the inherent powers, to exclude the new representation on the basis that although there is a right of parties to appoint their representatives, this must always give way to the tribunal's status and legitimacy and the integrity of the proceedings as a whole. And so in that case, the tribunal in fact did rule that Slovakia was not able to include new counsel on their team because it would present a perceived conflict of interest. We can contrast that with a case involving Romania, where a somewhat similar situation arose. There was new counsel that was proposed to take over the case because the previous counsel had left private practice. Unfortunately, the new counsel was a partner at a firm in which one of the tribunal members was practicing at. Although, of course, the new counsel by that stage had moved on to a new firm. But the gap between when he left the old firm and when he joined the new firm, I think was quite recent. In that case, the tribunal found also that there was an inherent power to regulate its own proceedings, but thought that because that power was not expressed, the default or the assumption must be that the parties had a very strong right to name who they wanted as their legal representatives, and that it would take extraordinary or exceptional circumstances in order to override that choice. And so you see the quotation there that the tribunal would only have exercised its powers in what it called compelling circumstances. And so in that case, it actually did not exclude the new representation and went further to actually try to distinguish the Slovakian decision as one in which the tribunal had basically sanctioned the parties for a late disclosure or improper disclosure, untimely disclosure, as opposed to a situation of dealing with new representation per se. So you can see that what has been happening is that although as a baseline, tribunals do accept that in special circumstances, they could exclude new representation where it would present a conflict with the tribunal or indeed potentially with the other party. The power or the threshold at which the power is exercised has been differing depending on how robust the tribunal viewed its inherent powers. Now, of course, that we have express power under the ICC rules, query whether that would mean that the decision in the Romanian case, for example, might have been different. So that, I think, remains to be seen, and maybe we can ask Hazel later on whether the ICC has had any experience dealing with these sorts of situations as well. Of course, Article 17 is not the only change in the rules, although this is not in the rules, but there have been changes made to the ICC note to parties and arbitral tribunals on the conduct of arbitration, which need to be read together with that. And I think the change in Article 17 is really consistent with growing concerns over how parties conduct themselves and their proceedings, and the ethical obligations on everyone, I think, to ensure an impartial process. So Section 3A, paragraph 27, for example, makes it clear that a tribunal's disclosure obligations extends not only to conflicts with the parties, but also to third-party funders and relationships with witnesses or experts. And I think we would have in mind, for example, in ICC in Spain, where there was a situation of an annulment of a treaty award where the arbitrator had failed to disclose relationships with an expert. So you can see that the running theme recently has been this serious concern to ensure the integrity of the process at all levels. And I think recently we've also read on the Global Arbitration Review a report of a German arbitrator which failed to make certain disclosures in relation to the work that his firm had been doing for the parent group of companies, a subsidiary of which was before him in an arbitration. And the Paris Court of Appeal actually not only annulled the award, but also said that he could be personally liable for his failure to disclose. So again, I think we can see Article 17 as being part of this momentum, I think, that is going, is making a very, very strong stand against these sorts of ethical breaches. There has also been a change to Section 5, paragraph 66 to 67, again, reinforcing the duties of parties and, well, in this case, the tribunal to be independent and impartial and to avoid any appearance of bias, and also an encouragement to adopt, where appropriate, the IBA guidelines of party representation in international arbitration. So this, those guidelines are now, I think, being hardwired into the arbitral process increasingly. So that wraps up the point on party representation. The second change that we wanted to discuss was in the case management techniques that are available to a tribunal to resolve a particular dispute that is before it. And in this case, you see that there are two parts to the Appendix 4, paragraph H, I suppose, settlement of disputes, where first a tribunal may encourage parties to consider settlement of the dispute, whether in part or in full, and two, where agreed between the parties and the tribunal may take steps to facilitate that settlement of dispute. We can contrast this with the 2017 version. Sorry, I don't have it on the slides, but the 2017 version of Appendix 4, where the tribunal would have the power to take steps to facilitate settlement of the dispute if agreed between the parties. So the sub clause 2 remains the same, but the provision in the 2017 version does not use the words encourage the parties, but just merely states that the parties are free to settle their disputes by negotiation or other forms of amicable dispute resolution methods. So there is a slight push, I guess, in the direction of empowering tribunals to be slightly more proactive in trying to resolve the dispute by other means than arbitration if thought appropriate in the circumstances. I suppose from a common lawyer's perspective, there might be some concern about exactly what tribunals might do with this power, and whether or not that might shift them into a mode away from their adjudicative functions. But really, I think one can see this slight revision as being, I think, consistent with the trend in many other forums, including national courts. I think those of us based in Singapore will know that we are revising our rules, our civil justice rules, and as part of that, courts will have more power to encourage parties to settle the disputes and even impose sanctions on them if they unreasonably fail to do so. So it's very interesting, I suppose, to see that the ICC also perceives the role of tribunals not only in a purely adjudicative function, but also in a wider sense of resolving the dispute that is before the tribunal. And it's also consistent with the recognition by UNCITRAL in its rules of organizing arbitral proceedings. You can see the shift over the last 10 years. In the 1996 version of the notes merely stated the obvious, that attitudes might differ as to whether it is appropriate for a tribunal to bring up the possibility of settlement. But then when we get to the 2016 version, a decade later, there is recognition that in appropriate circumstances, the tribunal can raise the possibility of settlement between the parties. This, of course, raises the question as to if the tribunal feels that it might be appropriate to encourage parties to settle, how it should go about doing it. And I guess the particular sensitivity when it comes to arbitrations is the need to ensure due process and equal treatment of the parties, so that I don't think it would be, for example, appropriate for a tribunal to say to one party, you know, your case is terrible, I think you should settle. Right? I think words to that effect will probably not be what is envisaged by the change in the case management techniques that are proposed by the ICC. But there are many variations in between. At one end, the tribunal, and I think we've seen this, or at least I've seen this in some cases, where the tribunal will say that in its procedural order number 1 even, that the tribunal may make inquiries of parties as to whether or not there have been settlement efforts. So I think that's at the softest end, and obviously if they can make inquiries, that might be one avenue through which they might softly propose some ways to settle certain parts of the dispute. They could also try to identify issues that are relevant and material in the exercise of their general case management powers. That's something they're obviously allowed to do, and something which, if they did, can sometimes prompt parties to realize that perhaps some parts of the case may not be relevant, or the parts that they're strongest in may not be relevant as well. So it might be a subtle way of sort of getting parties at an early stage to kind of recognize what are the key issues that concern the tribunal and how strong they are on those issues. Perhaps slightly more towards the other end of the spectrum might be even early indications on the merits. I think this will obviously require the parties' consent, because otherwise the tribunal might be opening itself to an accusation of prejudgment. And there is even the possibility of the tribunal conducting a full-fledged settlement conference, as it's called under the sort of the rules that have been promulgated by the Center for Effective Dispute Resolution. And this is where it is envisaged that the tribunal might actually sit with the parties in a separate proceeding to raise the possibility of settlement, and if so, what those terms might be. Now, all of these, I think, can fit within the rubric of the tribunal taking steps to facilitate the settlement of the dispute. But I think at every stage, the tribunal and obviously the parties themselves, I think we need to be very, very careful about ensuring that whatever happens in that process of facilitating settlement does not come back to undermine the integrity of the award should the settlement not actually take place and the tribunal actually has to render an award. So I have in mind, for example, ex parte communications, which might be fairly common if you were in a formal mediation setting, where the mediator goes off with one side and starts talking to them without the other party. I would be very careful about either consenting to that or as a tribunal member, perhaps even going down that road, unless there is very, very clear and express consent by the parties that that's allowed. And if so, I think the scope of that consent also probably has to be quite detailed in terms of what can be said or whether it's carte blanche in those ex parte communications. Because again, I think the last thing that the parties of the tribunal wants is some accusation that something has been said in those ex parte communications that now puts the other party at a disadvantage. But whatever the precise nuances in each particular proceeding, I think what these revisions do is really to, I think, signal a slight shift in terms of how arbitrators see their legitimacy. I think as not merely being founded on the adjudicative functions, but also to resolve the dispute more globally. And with that, I'll stop here. I don't know if Hazel wants to jump in with an ICC's perspective. If not, then I'll hand over the time to Kit. Thank you.
Thank you. I think you've pretty much covered very adequately the 2 points on party representation and on settlement. If I can just add 2 quick small points on both. Under Article 17.2, where the tribunal is now given the power to exclude party representation. This is quite a significant change, and understandably, there were a lot of concerns when the clause was first introduced. We have not yet seen in practice this power being exercised, and I think it remains to be seen how the tribunal will balance the need to avoid a belated change in the party representation, giving rise to conflicts, and on the other hand, parties' autonomy in selecting its own legal representation. It is not an easy balance exercise, but we have not yet seen that in practice. But I think the tribunal will be best placed to decide that. And on the second new power that you touched on, which is the encouragement of mediation. It's funny how the change of one simple word from notifying parties to encouraging parties. I mean, it doesn't seem like much, but it is consistent with ICC's commitment to promote more efficient resolution of disputes. And as you know, there's no surprise that our rule book comes with both the arbitration rules and the mediation rules in the same booklet. In fact, ICC has its own ADR center that handles all the mediations arising out of ICC cases. So it is a marked change, and it is an express commitment to assisting parties find a more efficient resolution of the dispute in whatever way possible. Thank you.
Thank you, Hazel, and also thank you, Paul, for leading the discussion on the tribunal's powers. And now I know that we only have about 15 minutes left before the 6 p.m. Timing. We will now go into the question and answer session. As I mentioned earlier, we actually had quite a few questions that streamed in during the last hour or so. I have unilaterally decided that we will answer 4 of them to the extent that they are probably more interesting, and also they're relevant in that sense. So most of the majority of these 4 questions actually deal with complex arbitrations, but that is not to say that we will not allow the other panelists, aside from Christine and Hazel, to touch on them. Perhaps I could firstly ask Hazel to look at question 1, and I think we all can see that the question reads as follows. I won't read it out again, but maybe Hazel can take us through that, and then we will also see whether any of our other panelists might want to chime in on it as well.
Thank you, Kit. The question relates to the new Article 43, which essentially provides that any claims in relation arising out of or in connection with administration of the arbitration proceedings by the courts under the rules shall be governed by French law as settled by the Paris Judicial Tribunal. So if you will, it is in essence a dispute resolution clause with the ICC in relation to administration of ICC arbitrations. And the question is whether, a concern as to whether this clause, because it does not expressly limit it to claims against the ICC court, officers and employees, would this actually impact on a party's choice to go to a non-fetch seat of arbitration if they raise an objection to a decision by the ICC. The example given was, for example, if the party wants to frame a challenge to an arbitrator as an objection to the court's decision to appoint, confirm, or reject a challenge. Well, the intention of the clause 43 is really in relation to claims regarding the administration by the court and the secretariat. I think that is the crux of it. And despite the fact that there is a limitation of liability clause under Article 41, it doesn't stop parties from actually trying to sue us. Please don't shoot the sheriff, as Loretta would have said in a previous seminar, don't shoot the sheriff. But it doesn't stop parties from trying. So the idea of Article 43 is, if you must sue us in relation to the administration of the cases, at least let it be in this particular forum where our ICC headquarters is, so that we can better manage it. And that's really the essence of that. For challenges to arbitrators, this should be raised to the court in any case under the rules. And I think the rules provide for that. So if there are any issues as to the decision on the appointment or challenge to arbitrator, this should be raised to the ICC court in any case, and it doesn't fall under Article 43. I hope that answers the question.
Any other panelists would like to chime in on this question? No? Okay, we'll move on to question 2 then. Question 2, as you can also read from the screen, deals with Article 7.5. I thought maybe I would ask Christine to take a stab at this one.
Thanks, Kit. Well, I'm happy to share that with Hazel, but I'm not sure actually. I was looking at the requirements on the 7, and I'm not sure there is a burden of proof per se to prove a link with another party. I think what needs to be shown in the request for joinder is that the additional party is a party to the arbitration agreement, that there is the dispute involves this additional party, that there is any claim made against by this additional party and the reliefs. And well, any burden of proof, all of that is for the applying party. But I wanted to ask Hazel if there is a burden of proof to prove a link between the additional party and a party in the arbitration, an existing party.
Well, I echo your comments. I think Article 75 doesn't require a link to be established. My understanding of the question is that it follows on from the last point that we discussed, where you mentioned that if an additional party wants to come in, who will be the one to pull them in? And essentially, in practice, what happens is it depends on the party who wants the additional party to be joined. So the burden, in effect, rests on the party who wants to join the additional party to establish that they should be joined. So that usually is what actually happens in the cases. But as you have rightly pointed out, Article 75 doesn't have such a requirement. So I think that there is no actual requirement to establish a link between the relationships of the parties. And if I may just point out, the second part of the question is in relation to where the ICC line is drawn to delineate a plausible commercial interest of relationship. Under Article 75, the line is drawn by the tribunal. And you have rightly pointed out that Article 75 doesn't specify how this line will be drawn by the tribunal, precisely because it is difficult to have one test that applies for all situations. So what we have tried to do is we've given guidance on what are the factors to consider, but it will still be for the tribunal to decide on a case-by-case basis, based on the facts before him, whether there is actually a conflict or not, whether there is a plausible commercial interest of relationship or not. So it's hard for me to say where the line will be drawn because it depends on the case. I'm sorry, that's the best I can say, but it does depend on the case.
Thank you, Hazel and Christine. If we can move on to questions 3 and 4 now, I'll just have to trouble Hazel and Christine to still stay on this. They are short questions, but again, they go back to the complex arbitration provisions. So perhaps I could just have both of you also look at answering these 2 questions, please.
Happy to take this question 3 first. And the question really goes to the crux of it. Article 10b, as we have discussed, introduces arbitration agreements in the plural, which allows the court to consolidate where there is more than one arbitration agreement being relied on. But the question was, why is it that when the court decides prima facie jurisdiction under Article 6.4, the reference is still to a singular arbitration agreement? And is there a discrepancy? I think this really highlights the low threshold which the court takes into account for prima facie jurisdiction under 6.4. As long as an arbitration agreement binding on parties can be established, the court will allow it to go on, and it will be for the tribunal to make a decision on the jurisdiction eventually. So this is not a discrepancy. It is not the same, but it's intentional. It actually underscores the low threshold of a 6.4 decision decided by the court. As long as an arbitration agreement under the rules binding on parties can be found, it will probably go through.
Christine, anything to add to that?
What can I add to that? Nothing.
Okay, well, that brings us to the final question, which I actually think is quite an interesting one, both from the interpretation of the clause itself, as well as whether or not it actually does go far-reaching enough to accommodate possibilities of class action. Maybe I will ask Hazel to touch on it first, and then we could see whether any of our other panelists may have experience on this particular topic.
Sure, happy to. I think the long and short of the answer is, as long as the cases satisfy Article 10b, then it will be consolidated. And there's no limitation against class action suits in that sense. In fact, I just wanted to highlight that in one of the cases, the Singapore office is actually a mystery. There is almost 100 respondents in one of our cases, and we have continued with the arbitration as per usual. So we don't limit it to a particular number of parties or respondents.
Right. Any of our other panelists may have experience on this particular point who would like to also provide some input? No? Well, if not, then I think we've done well. We've been keeping to time. And in the last 5 minutes or so, I would like to first call on Abhinav Bhushan, the regional director for ICC Court here in Singapore, to close us off before we have Smitha come back in to say a goodbye to all of us before we go for happy hours. Abhi.
Thank you. Thank you so much. I practically cannot add anything more to what has already been very eloquently deliberated by all the wonderful panelists. But sort of just to close it, and what we have been doing and why we have been doing. As many of you may also know, I'm sort of towards the end of my innings at the ICC, and I'll probably be leaving the ICC on the 31st. But having spent 10 years at the ICC now, I think what I can confidently say is that every time the ICC changes something, the ICC does it obviously quite cautiously, and this is something that Smitha said in the beginning. Since the court actually was established, and the court was established as a repercussion of the First World War, when the ICC was established in 1919, and the court was established in 1923. The fact remains, that of course there is a lot of arbitration in Asia, there's a lot of arbitration in the world, and yes, there is competition. But insofar as ICC is concerned, and I always try and go back to the very ethos of what the ICC does, the fact remains that the ICC drafted the first draft of the New York Convention. The fact remains that the ICC remains the #1 institution in the world by all credible rankings, surveys, and reports. The fact remains that we are perhaps the only arbitral institution in the world that services arbitration and clients from 5 different jurisdictions, that is Paris, Hong Kong, New York, Sao Paulo, Singapore, and now the 6th in Abu Dhabi. The fact remains that we publicly publish the names of the arbitrators, and perhaps the only institution that sanctions arbitrators if they don't do the job properly. The fact also remains that we have the largest number of arbitration practitioners and experts Hazel is one of them who works at the Secretariat and leads the team in Singapore around the world compared to any other arbitral institution in the world. The fact remains that we just don't talk about diversity. We also show what we do. And that's what Smitha again alluded to at the beginning of the seminar, that we now have the first female president of the ICC court. And today the ICC court represents more women than men. The fact remains that I think we believe that change is the only constant that must remain for anything to evolve. And whenever we do that cautiously. The cast, I think, the star cast rather, that is presenting to you today. I mean, I always say this, that the cast that I come from and I belong to is the ICC cast, which has always stood for, I think, consistency, accountability, stability, efficiency, and transparency. And these are the core ethos of ICC. And it is these ethos which have prompted the 2021 rules. Every single change that has gone into the rules has been deliberated upon months after months by the world's leading experts, and of course the ICC Council and the governing board and so on and so forth. Every single change caters further to transparency, caters further to accountability. And I think that what Asia needs today, and I think what the ICC needs to continue to do, is to promote the use of arbitration and the strength of arbitration in the ever-evolving and the developing parts of the developing world, which of course Asia is one of it. So I will unfortunately not add to the technicality of the rules, because much has been said, and I think it has been said way better than what I can do. But I would encourage all the users and all the lawyers and the clients, as we like to say it, as I like to say it, or the new president of the court, Claudia Salomon, likes to say it. You're all encouraged to reach out to the institutions. You're all encouraged to reach out to the secretariats. And we provide a lot of help, a lot of assistance, even at the stage of drafting arbitration agreements, how best you can draft your arbitration agreements, what perhaps are the disadvantages or advantages of choosing one seat over another, or what are different considerations the parties can take into account while drafting those interesting contracts. So thank you very much. And thank you so much for organizing this webinar. And thank you to the Singapore Business Federation and to the ICC Singapore Arbitration Group for putting this together. And I look forward to being around at the ICC another 29, 28 days.
Thank you, Abhi. And then, as we all know, even though we do leave the ICC at some point in our careers, and even when we go back to practice, we all still retain very strong links with the institution. And this only leaves me to call upon our court member for Singapore, Smitha, to give a closing remarks, and we can then all go for happy hours. Thank you.
Well, in the last minute, I just want to make one point, which is that the fact that Kit is here as part of this thought leadership committee, which is also co-headed by Paul, shows that the ICC community, you never actually leave it. So if you would like to be part of the ICC community, please join the ICC Singapore Arbitration Group. And you can just email the same email address you used to sign up for this webinar to ask for the application form. Thank you, everyone, and have a good weekend.